Howdy, we're going to be talking about Texas Rule of Evidence 408. It is on compromise offers and negotiations. This is primarily a civil rule. Again, the Texas Rules of Evidence used to have separate civil rules and criminal rules. They are combined now. There is a rule basically that says in a criminal case, you can't use a plea bargain negotiation against that person in trial. So, like if your defense attorney says, hey, we would plead guilty if you give us this reduced sentence, you can't then introduce that statement into evidence against the defendant. It'd be hearsay anyway, but it's a plea bargain negotiation. But this is talking about compromise offers and negotiations, and that is for a civil claim. So, for example, if you slip and fall at Walmart and they offer to pay you a settlement, you cannot use that offer against them at trial to prove that they negligently kept their store floors unreasonably slippery. Okay. It's a good rule to have in a legal system because it allows us to negotiate back and forth without fear that it's going to be used against one of the parties. Uh, the other rules related to this are rules 409 and 410, which cover offers to pay medical expenses and plea negotiations in criminal cases that are also designed to encourage people to attempt a resolution of their differences without going to trial. So the next up thing we're going to be looking at is going to be some case law on the matter, but it's pretty simple. You'll be able to get it. I'm going to give you the citations. And here we go. The case law we're going to be talking about is Ford Motor Company versus Leggett, which we've got the citation there that you can see. It's just flat out. It's discussing this rule. It's from 1995. Settlement agreements are not admissible at a trial to prove the issue of liability. Now, this is something that people ask me sometimes is, well, isn't the store guilty of doing something wrong? Or isn't that other driver guilty of hitting me negligently and then they're going to owe me money? Well, there's no such thing as guilty in a civil case. It's only liable or not liable. Guilty and not guilty is only in the criminal context. And so, again, for this rule, we're going to be looking at liability. So the other case we've got is Vincent Minerals LT versus XTO Energy Incorporated. And this was a letter that was sent trying to attempt to settle the disagreement. If we will pay you this amount of money, or finish the work in this amount of time, can we resolve this difference? Well, that is not going to be admissible as a admission by that person that they've done wrong because it's a settlement, it's a negotiation, and you don't get to use settlements or negotiations against the other party in a civil lawsuit. And that is because of Texas Rule of Evidence 408. Thanks for stopping by. As always, these are just for educational purposes, and we hope to see you next time. Don't forget to like and subscribe if you like what you saw.